Ladies and gentlemen, dear colleagues, in Sremski Karlovci, in the year 1699, in the Palace of Peace, there were negotiations held for the first time, as the history teaches us, at the Round Table. Today's meeting, the Round Table, is held in the different circumstances that, as the consequence, do not have the historical changes, but for the legal profession of Serbia are very crucial. Never in the history of the legal profession of Serbia, the executive authority did not do on such a direct and systematic way disturb the rights of the citizens. We owe our thanks to the representatives of bar chambers of different countries, Romania, Croatia, Federation of Bosnia and Herzegovina, Macedonia, Slovenia, Hungary, and I would announce Mr. Srđan Simikić, the representative of the Bar Association of... I would like to wish you the pleasant stay here in Karlovci. We have already the announcement for the Karlovac peace that entered the history of the peaceful negotiation and the notion of the Round Table. So this notion comes from this place, the oldest high school and the church. The church seats in 1848 until the 1900 and. In the year 1848, from the balcony of this building, Vojvodina was pronounced. This is just a short memory of what is significant for Karlovci. So, the first of all is the message of peace, and I really believe that from this meeting we'll have the message of reason. Thank you for your support that you're giving, and thank you for being the guest of Karlovci. Thank you, Mr. Milenko Filipovic, and now I would like to announce Srđan Sikimić, the representative of the Bar Chamber, the Bar Association of Serbia. Dear colleagues, dear friends, I greet all the participants of all this round table, and especially the representative of European Council of Bar and Legal Chambers, Ranko Pelisaric, and representatives of bar associations of Slovenia, Hungary, Bosnia and Herzegovina, Macedonia, and Romania. Unfortunately, our colleagues from Greece could not come here, and as you know, they are already in the protest with the problem that they have with the new legislative system in Greece. My greetings, my thanks to our host, and thank you for the organization and coming here upon our invitation of the Bar Association in Serbia and the Bar Association of Vojvodina. I would like to greet the members of the Managing Board of the Bar Association of Serbia, representatives, presidents of these bar associations. We are holding this round table in the 73rd day of the protest of legal workers, of the barristers in Serbia. It is really clear that to the authority and the public what are the reasons of our protest, and I will use this opportunity to tell about the point of this protest. The executive authority abused the law in order to obtain the monopoly position of the position of public notaries, so that it prescribed the public notary record as one of the form of all legal businesses on one side, and this way limiting the rights of the citizens to draw legal businesses, and on the other side with the other businesses that are drafted on the part of the lawyers or advocates. In this way, the executive authority went away of the scope of its authorization and obligations, and the basic principles of the United Nations and the role of the bar. In the corpus of human rights that are guaranteed by the Constitution of Serbia, the legal profession has the right to provide a service to the citizens as the independent and autonomous service. Disturbing this independence and autonomy of the legal service, there is a question of the rule of law came into the disturbance. The reason for the protest was the series of the laws on the legal procedure, on the bar, and those the law on real estate, the law on proceedings, the law on matrimonial law and inheritance law. And here is in the preparation there is a draw on the free legal protection and legal on mediation. All the way from the beginning of the protest, apart from all the requirements for the debate, for the talk with the Ministry of Justice, there is a lack with the communication that is manifested with the ignorance of the representatives to talk with us. We are aware of the fact that with the dialogue we can solve the controversial problems, the controversial issues, but there is no dialogue. It is not with our fault. And the form of the protest may be considered in that issue, in that light, having in mind that it is utterly specific and at the same time atypical for the democratic societies in which we have dominant rule or law. There are two topics. The first one are current issues of the legal profession, to what extent they get the communication with the authorities in their countries, and in what ways they are engaged involved in the development of the legal system. The second is related to the legal profession and public notaries. That means that we expect to know the true solutions and the consequences of the relations between the legal profession and public notary system. We expect to get the document that will publish our attitudes for these issues. Thank you to all the participants, and thank you for attention. I would kindly ask the representative of the Chamber of Vojvodina, Mr. Dragoljub Đorđević, to come. Thank you, first of all. Thank you, my colleague, and thank you, the mayor of this historic place, the center of our culture. the mayor Milenko Filipovic, and I would also like to thank the Bar Association of Vojvodina, who is a co-organizer of this event together with the Bar Association of Serbia. I would like to thank our international friends that are here with us, as our friends, as people who understand the challenges and dangers of the legal profession when it comes to the basic mission for the protection of human rights. Our protest started pretty naive with so-called ritual announcement to the executive authorities when it comes to the tax system, fixed rate tax system, and these negotiations should not have lasted long than 5 days. This time, the negotiations started in May. In September, we realized that no one is negotiating with us, although we had the formally established working group. That means that if you don't want to solve the solution, to make the solution, you should make the working group, and then we have it done. We started our protest on the 10th of September. I would like to tell you that there are 3,700 attorneys at law. And there are 8,600 attorneys at law altogether in Serbia. Then there was the assembly of the Bar Association on the 13th of September with decision to enter the protest. And a representative of the Bar Chamber of Vojvodina, Mr. Sikimic, said that we have a typical protest, and this is the reason is that it represents one of the ways to say that we are not satisfied in our legal profession. It is really necessary to do in the purpose of its existence, in the purpose of the protection of human rights, the struggle to provide the rule of law and security. Of course, the legal profession, with its public interest, does it through its function. I do not have to explain to the attorneys, first of all, because of its mission, professional protection that it offers of the basic human rights, and the protection of the clients. Why do we say it's a typical protest? As far as we know, in the countries members of the European Union, it has never come to such a drastic protest, and there is no wonder. There are the states; these are the states that have a long tradition of respect of human rights, and the law of protection of human rights is something essential. The systematic things are so devastated that the rule of law is not so important. They say that due to the protest of the attorneys, of the advocates, everything is at the standstill for a particular period. So it cannot be understandable in some of the countries. Here, for us in Serbia, it is something normal. When the legal system, barrister does not cooperate. If you come from the state where the rule of law is essence, then there will be the scandal. In this country, it is not the scandal. In this country, it has already been seen. It's déjà vu. I have to explain to those of you who are listening and wonder who have high respect of the rule of law. I have to explain that the legal profession is not at the has not been at the standstill for 2.5 months. The legal profession has been at the standstill for several years. At some particular point, 4 years ago, it says that 800 or 900 of judges and the equal number of prosecutors should be dealt with improper, and the system which has not ever been seen in any system. There are very bad consequences in the legal profession. Everything stopped. We had the new judges, new people are named, more than 40 courts were denounced. The proceedings got the new forms, the judges got the proceedings, the problems that were older than 20 years. They got completely new obligations, and no one could manage his way in this chaos. And then came the new government, and if we want to make it better, we have to call it the right name. So it came that over the night, by the decision of the constitutional law, there should be the priest of law when it comes to the Supreme Court of the country. So here, the Supreme Court, a night after the elections, came to the decision that all the judges should come back. It did not do months or years before that, but it did after, in one night, after the new elections, after the new government came into force. It came into force. Some of them came back to their positions. I know that for some of you that you come from the different countries, that this is something unbelievable. I apologize to all of you who have spent your time since I have been telling you that this is in fact the story of the Alice in Wonderland. But in order to realize what the bar is doing here in Serbia, it was necessary for you to hear this story. After the new old judges came to their positions, we came into the situation that we had 40 courts again, and that we all had the old council specs and the new categories of judges. This is what we call 3-year term judges, and whose destiny was decided upon after the 3 years, when it was decided whether they were the suitable ones according to their work. So the principle in all the democratic countries for the division of the authorities on judicial, legislative and executive, the courts became part of executive authority. The judges also became that. There are exceptional views, but there is a mass of those who are afraid, people who should be independent and autonomous. You have judges who are in some kind of fear that they have to take care because they know that overnight someone can take their position and that on the next day they cannot support their families. and there are the judges that, to that extent, that change their consciousness, that they deal with the so-called self-censorship. Self-censorship is what I call, in order to be more appropriate to the Big Brother. Coming from that situation, we come to the position of the legal profession when it came to the syndrome of accumulated affect, when it all expanded. We came across the Rubicon, and we came into this protest that has been lasting for a very long period. Why the executive authority is not worried about with this one? So, why it is not a worry of the authority who would like to be the part of the European Union? They do not worry because the legal system is under blockade in the previous 4 years, and they will not see that. What I would like to say to all of you is a sentence that was said by one of my colleagues that says so much that depicts the situation. When the judges stop to go to their work, and when they start to judge, it's only then when we can regain our trust in the judicial system. The legal profession is here today is in such condition that even the oldest colleagues do not remember so unscrupulous and the attack of the executive authority to this profession. So it is the attempt to extinguish the light of the oldest profession. When we talk about Serbia in the year 1864, the beginning of the law, and the territory of Vojvodina even longer, when we have into consideration the Austro-Hungarian kingdom. The whole issue is more complicated with the drafting of the set of laws that the bar would not see that it is not only about the diminishing the rights of the citizens. It will enable the professional capacities of all the citizens, university professors, as it seems that these people would not be able to draft any document, and that the notary may say what you have written is nonsense and I can do better than that. The situation is unfortunately here the same as in the other countries, neighboring countries, but the consequences are not the same. Dear colleagues, those of you who do not live here in Serbia, do you know that there is 60% of real estate that are not legitimate? So this is, they do not go through any public register. From the aspect of legal security, I do not have to tell you. The conclusions are unequivocal. And there is a great problem with corruption. We have started to talk about it, not because we have the fear to talk about that, because we realize that we struck into the public and private partnership. Public notary is a very important issue, very important problem issue. If we say that for real estate declaration, you know what I mean, you want to know what it is, I can do that without any charge to my clients. So when it comes to for example, the real estate for 10 million euros. I paid for that. The tax for that that I paid was approximately 15 euros. For such real estate value, the public notary would get 600,000 euros, and the client would have to pay additional taxes that would be equal to 620,000. That means 6,800 euros for the real estate statement. Again, I'm repeating so that you may not think that I have said it wrongly. 6,800 euros. This is an example that says why Serbia has dropped in 40 places. That this is not the suitable place for foreign investment. The point is the rule of law. So if you know that 8,500 attorneys at law said that you are wrong, so there is no dilemma. So it is true that you're 100% wrong. So if you will win if you admit that, and if you do something to the good purpose of the citizens. The issues came like this, that the executive authority is dealing with in political manner. I hope that the Prime Minister of Serbia would for the first time, has his announcement. Of course, it would be the announcement that we should have discussion. It would form the working group that would start to deal with the problems that have been piled up. All of us who agree with all these consequences, if we are not in the position to invite you, to tell you that we have problems, that we are deprived of our freedom. Any attorney from this country would say that it has never happened on this territory, that in one place, even when there was the Social Federal Republic of Yugoslavia with 22 million of inhabitants, it has never happened that there were 4,500 attorneys at law gathered in one place. Many of you have been present there, and they said it will never happen again. It happened now, and it will never happen. And then in front of the government there were 5,000, and on the square of Nikola Pasic there were 6,500. And if these things are happening over and over again, and if the barristers invested everything that they had in this idea, so this is the issue that we should ask: what is happening? There were arguments about the minimum of work, and we are declaring it to our executive authorities. What the Minister of Justice had and his cabinet with the representatives of international organizations, they represent it in the way that was suitable to them. It is, of course, the minimum of work that prescribes the protection, first of all, of vulnerable groups. We have this minimum of work when it comes to juvenile things and crime, and what we think about, what we have in mind is the decision of the Bar Association, that means the objection, and this is a decision that is still on his effect. They say that there are attorneys that they would like to work, and that there is the chart that says that it's upon the attorney to decide. If someone says that it is not legal to go on protest, it is not legal if they do not do, these associates do not do according to the principles. If it is like that, it will be applied like that. What I have heard from the seat of the organization from the organization of Mr. Pelicevic, will have soon in a couple of days debating about this in Brussels, not only about the issue that is happening in Serbia. There is no position of European Union that regulates the rules of the minimum of work when it comes to this situation. No one has ever thought that something like this could happen in the 21st century in Europe. Everybody has a right to his opinion, and the Serbian legal profession notary system. For the end, I will only tell you that that Serbian legal profession is not against the public notary system. We are, in fact, against the system and the way it is established in Serbia, and the way related to the election of public notaries, the election and establishing. There is 100 public notaries prescribed for such thing, but there are only 90 of them, so not enough number of public notaries. So they could not get 100 of those who are suitable for great sums of money in the period when this country is suffering from a very difficult economic situation. You can also see that it is the system of corruption and the violation of the rights of citizens of Serbia. I would like to end that unconsciously we struck on what I have said, that is the public and private relation.
Sada bih pozvao advokata iz Novog Sada, magistra Mila Koraća, da iznese kratak referat na
The issues that are related to the drafting and certification of statements are determined with the different laws, the law on real estate controls, the laws on the certification of manuscript signatures. There are the laws on the declaration of will. Since there are the rules that are not constituent with other issues, there are different proceedings for the evaluation of the constitutional point and whether they are constitutionally related. All these proceedings are not finished. Even if they are, there is the justifiable question to what extent the decisions of the Constitutional Court can enhance the text, improve the text, and that would mean that they would deal with the situation and try to solve the situation, solve this problem of the protest of the legal profession in Serbia. I would talk about the documents, public notary documents, and the certification of the documents, drafting and certification of documents according to the previous laws, drafting and certification of documents according to the present laws and regulations. I would like to give suggestions that that are necessary of some provisions of the law on public notary and the regulations, related regulations. The topic of my talk is about public and non-public statement. It is about the law on the general proceedings. The public documents are those that have the appropriate form. Issued by the authorities, issued by legal and physical persons, and those authorities were given to them by the law. All the other documents are non-public documents. That means those that are private documents. That means that they originate from physical persons, or those that originate from public authorities when they do not publish it in the boundaries of their authorship, or in other persons if they do not publish it in performance, their public performance. The public notary did according to the regulations in the form that it drafted, issued, signed, or just confirmed. The law on public notary. There are four of these forms. These are documents, minutes, certificates, and what we would like to deal are just the documents, and I will tell you in short about the documents that are issued, the records that are issued by the public notaries. In the form that was drafted, and that with his stamp or seal and the signature he confirmed, which means that it is the proof that this is the public document. It means that it is not public document, that there is a proof, the proof of the public notary that makes it, put it in the same level with the public. So it can have the importance of the executive document. There is the separate clause or the stamp of the public notary that confirms the authenticity of a particular signature or the hand sign on the document. And there is the copy or the transcript or the translation. When it comes to the public notary record, there is just a notice on the certification or the confirmation of that record, or the legal process that is described into that. Apart from the authentic text of the document and the signature of the other participants in the document, in all the other things, this record is non-public document, which means that according to these regulations is equal to the public. It all means that when it comes to the certification, the importance is the clause of the public notary, and when it comes to the public notary certification, there is only the clause on the certification of the signature or the hand signed on the document. When it comes to certification of the document, it comes to the simple certification of the signature on the document, and sometimes on the certification of the certificate of the document as a whole. It means that it is a certification of the document, and in the second, it is solemnization of the document. When it comes to the certification of the signature or the legalization of the document, it means that the public notary confirms that the signature or the fingerprint comes from the person who signed the document or put on the document, or the person who the person who signed it confirmed as his. When it comes to the confirmation of the non-public document, the notary public confirms the authenticity of the text that is above the signature or above the fingerprint. It is important to note down that that is not confirmed the truth of the document. When it comes to drafting or certification of the documents according to the previous regulations, we can say that these regulations did not have any limits when it comes to the possibilities of drafting these statements. With the exclusion of the legal statement, only the judge could do that, with exclusion of other documents of similar origin or nature or similar type, which could be drafted by particular certain official persons. Any other person could draft the statement, even the person who did not have the legal qualifications. According to the previous legal prescriptions from 1993, the procedure of making the content of the document was prescribed by the provisions of the law on non-litigious proceedings, with the provisions with material and legal regulations and other statements of wealth. With these statements, since these statements were drafted by the lawyers as professionals, it was done without any problems in the non-litigious procedure. If there were some discrepancies, these discrepancies were corrected during the proceedings. Drafting and certifying the documents with the new law on public notaries, there are many disputes about the possibilities of drafting the documents and the decisions about the legal issues on the legal testifying of the will of litigants. In this form of the public notary form, we have these contracts of real estate among spouses, and some kind of contracts about real estate of those vulnerable groups.
Sporazumi o deobi zajedničke imovine
contracts on lifelong support,
o zakonskom izdržavanju u skladu sa
contracts
zakonom,
on presence in case of death and other legal businesses, and the documents that they have to be drafted in the form of public notary, in form of public notary regulation, in the provision of the Article 83, they can be concluded, made or given. These decisions or declarations in case of that of the founder of the foundation, legalizations, the statements from exclusion from inheritance, inheritance laws, the inheritance of the present to inheritance, that the present will not be involved in the inheritance, the death that would not be included in the inheritance, in the admittance of the fathership, acceptance of the biomedical fathership, declaration of fathership, or other forms of documents that have to be stated in that form. That means that public notaryship is obligatory, and sometimes it is competitive form when it comes to conclusion of the will of the litigants. I will tell you about the paragraph form of the different clauses that there are contracts on the distribution of real estate in lifetime and lifelong support. They should be done in the written form and certified or confirmed, better to say, by the judge, not by the public notary, as it comes from the regulations of the present law on public notaries. So that means that in the written form, the marital contract has to be drafted according to the Article 188, paragraph 2 on the law on the matrimonial law. So they did not have this into consideration. That they said that even these contracts have to be dealt in the form of public notary. That means that there is a new problem of the provision of regulation. With the provisions of this new law, the contracts they say that there is a transfer of the right to transfer real estate in the form of real estate record or in the form of the written and solemnized or form. So to say that these forms, when they are established in the written and confirmed document, they have to be in the content that they would be related to this form. We have to notice that this law on the real estate is not exclude the exclusivity on the right on the real estate or the use of the real estate in the ownership. This is the exclusive right that is present and that worsens the procedure and puts these public notary helpers and the drafters of their public notary facts. I will give myself the right to say about the provisions of this law on public notary and other related regulations. Starting from the above stated, I think that this law on public notary, that there is discrepancies and things that are not clearly stated. And we are sure that the decisions are in collision with the Constitution and the law, with the aim to improve that law. There is the prepositions and the directions for the changes and amendments of that law. Since we have that in the Article 1 of that article, organization, activity and other issues that are important for the public notaries public, it could not be prescribed the form or of the closely stated facts, apart from stating the contract on real estate belonging to the people who are not with working capacities, with the will that is with the material and obligatory regulations on inheritance and family regulations. Therefore, I think that the provision of the Law 83 has to be changed. It has to be said that in the form of public notary records, there should be the contract about the disposal of the minor citizens or the citizens without working capacities, and the contracts that involve persons who cannot read or write, or the public works that were prescribed by the law, that can be drafted or given in the form of the notary public records. For some of the declarations or statements, which is the material right, and it is not the establishing of the right to public notary, they can be concluded or given either in the form of public notary record or in the form of written and according to the law solemnized document, having in mind that both of those that I stated, perpetuating of illegal profession, they produce the same legal effects. When it comes from the citizenship or the law on citizenship, when it comes to the will of the litigants, we should abolish the exclusivity, or what we say colloquially, the monopoly of the public notaries in accepting the drafting of some of the documents that are really by their nature, and since that there is the prescribed procedures with the participation of other participants of this procedure. Hereby, I think about the drafting of the contracts on real estate contracts and other contracts that are related to the persons who cannot read or write, as well as the drafting the public notary record in relation with this document.
Javnobilježničkog zaveštanja
So I think that the provisions of the Article 93 is not correct when the public notary can certify only if it is in a form that is prescribed for the public. Since we believe it is unjustifiable given to the persons who are not public notaries. This provision should be abolished, and it should be prescribed that the public notary is due to confirm or to solemnize the non-public document under the condition if this document is properly written with the form and the content, it fulfills the conditions that are prescribed by law for the particular purpose in the law. In the case of solemnization of the document drafted by the document which is supplied by the lawyers, the attorneys, signature and stamp, it could be dealing with the content, the morale, and pointing to the litigants on the consequences. And finally, I would like to say that with the last amendment on the public notaryship and the real estate contract, there is not the exclusivity and the monopoly of the public notaries and the other public businesses and the declaration of the wills of the litigants. The latest amendments open the doors to further broadening of quasi-public notaryship, which would be supported by different agencies for real estate. It would be qualified as a criminal act. Drafting the documents by the people who work for the agency that provides the services of real estate exchange. I just wanted to explain. Thank you. I just wanted to explain my view. Thank you, Mr. Korać. I would like to announce the representative of the Bar Association of Croatia. I consider this meeting as a working meeting. I am greeting you in the name of the President. Thank you very much. I am, in fact, the co-president of the PECO committee of CCBE. You inaugurated me. Thank you very much for that. Now I would go to the insight of the current situation in Croatia with the insight of the history of the public notary in Croatia in the recent times. If we consider this period from the collision of the former Yugoslavia, and there is the law on public notaries that drafted in 1993 that that everything was the same as it was in the former Yugoslavia. From the 1993 until this recent day, it has been changed. There were no drastic changes. There have not been drastic changes. And you can see that there are new authorization given to the public notaries, and the citizens do not have any complaints. And we think that these amendments of the authorization of the public notarship, they contributed not very much. But they contributed to enhance the date or speed. So what is happening now? In Croatia, we do not think, we do not consider these changes as you consider it here. We do not consider them as the attack to the legal issues, to the constitutional law. We do not consider them these facts, these amendments. We do not find them as a disturbance of our clients and citizens and legal subjects in Croatia. These amendments went into the direction that it is that there are no questions about the real estate contracts, and they went from the authority of the court into the authority of the public notarship, and they came into we could enhance the speed or the time to solve these issues. So in case that there is controversy, then the court takes this issue and finalizes it in the court procedure. Only one type of executive power is given to the public notarship when it comes to the bank accounts and of the physical and legal subjects. So we do not find it as an attack. We greet it when it happened, reading between the lines. There are situations when we noticed that particular offices have different relations with the public notaries, and they can be done in due course, in due time. Life is life, people are people. I can sign now, and I share the opinion with the other lawyers that if we get some things more quicker, then it contributes. So when we draft these statements, the statements that are based on the law, and the official certification of the statements and of the present, based on the present law, that there is official certification of the private documents, and these private documents, I would say, they're 80% are equal to the public documents. I will state that my colleague has already said, as his proposal, that it is necessary for the legal due course for particular legal issues. It is when it comes to the real estate issues of the vulnerable groups, of people who cannot read or write, and we come to 600 or 500 euros without the form of public notary act. That there is also present contracts
proći.
You are civilist, and it is clearly obvious when it is there is not the legal presenting of the thing that there is a possibility that some of the litigants, one of the litigants, did not understand some of the statements. And when it comes to the dealing with of the citizens who cannot read or write with these issues, it is at their disposal that they need this kind of treatment. If we do not deal with legal procedures that they would do with the public notaryship, they can do this at the public notary public. When it comes to the certificate, they can all come. They can all come to certificate. Their signature. The public notary does not have the right to ask who did it, who drafted the document. Anyone could do that. In any case, when the public notary confirms the authenticity of the person, he does not have any involvement, anything to deal with the content. The other thing is solemnization. With the more firm position of the public notary, that means more security with the content of the act, or the content of the record, and the public notary is not required to ask who the person who drafted the document. He cannot say. He say that there should be the dot, that there should be numbers written in letters as well, not only 12 in numbers, but also in letters. From what I have told, when it comes to the relationship, our relationship with the public notaries, they do not have the exclusive right in contracting, in drafting any kinds of contracts. And I have to say, and for now, I think that public notaries keep to that. They're excessive. There are other situations, of course, when the litigant or the party comes with his own text and he says, I have to, the public notary says, I have to draft it or to write a document, then the party can accept it as the solution. And there were the situations that we have to deal on the basis of each single case. This is why you asked one of you to come from Croatia to present the situation in our country, and we're really interested that you get the similar solutions here, and that you know bad news comes through borders rather than good news, of course. I support you in your endeavor that your profession comes into your scope, not just for your sake, but for the sake of the parties.
Dakle, ja stvarno mogu reći i osobno i kao predstavnik komore da vas podržavam u vašem nastojanju da se vaš posao vrati u vaše okvire, ali ne zbog vas, nego zbog naših stranaka. Hvala vam lijepa.
Thank you very much, Ranko Prličević, and the representative of CCBE. Now, Roman Završek, the president of the Bar Association of Slovenia.
Hvala na pozivu.
Thank you very much for your invitation. I will speak in Serbian, Croatian, maybe Bosnian. There may be some words in Slovenian, so please do not mind me. Thank you for your invitation. First of all, I would like to greet you in front of all Slovenian barristers to support you for your independence and for all the work that was done by you may come into your force again. Thank you for the organization of this working meeting. I was asked to present the position of the legal profession in Slovenia in relation to the public notary system. I would not take long. At the beginning, I would like to say what is the most important and what comes as the first mission, whether to consider the public notary or the law on public notaries as something as which is opponent or there are the changes that there are enough lawyers that there should not be notary system, but then it was established, and what is happening that the lawyers do not consider the notaries as their competitors, that there is the mutual work and there is a good relationship, they are good cooperatives. Why? Because in many cases that there is a decency to do some documents. Public notaries ask the lawyers to prepare those acts, to write those documents, and for our parties, it seems that lawyers prepare everything and that the public notaries just finalize it and put the records with the dashes, etc. So what are the things that are done by the lawyers and what are the things that are done by the notaries public? There are 49 public notaries when in comparing with 1,600 lawyers. There have been amendments and all of them. It means that there is decreased number of public notaries and decreased tariffs to them. The criteria to elect or choose the public notaries to each court, to the level of the court, basic court or high court. So one public notary for each court on the territories with great capacity, with great number of population, for 1,000 of citizens, one public notaries. So these are the changes that went in the direction to decrease the tariff. So now they are complaining that there are too many of them when compared to the the population of the particular territory. Why are they decent? What do they do? As my colleague Ranko said, they contract the lease, the statement of will, out of which they gain certain rights. They get the responsibility, they get the papers according to different criteria that are drafted in the documents. They do according to the orders, according to the orders of the court. Since they do not do at the court and they are not due to work at the court, they can do on some cases when they did some kind of notary record, and we do not have statistical data about that. When it comes to that, the notary certifies the lawyer to do this instead of him. They draft the contracts, and the law says only to some extent what should be put. These are the contracts about marital spouses on concubinal partners.
when it comes to the distribution of the property of the people without working capacity and the contracts about the lifelong support and the contracts about the distribution of inheritance during the life and the contracts or the statements on present and the contracts on giving the presents after the death and other legal issues who are not conscious of doing this for themselves. Those are deaf or blind persons who cannot do this for themselves. When I said that in the year 91, when there was a draft on the law on public notaries, that there was a suggestion that we do not need the notaries, that the lawyers are conscious enough, and there was the reorganization of the courts, and in the year 94 or 95 there were many things that should be dealt at courts, some cases that have been waiting, and they offered their services so they could decrease the number of the issues that waited at court. Some of the documents were certified at city halls, or some of the documents that there should be provided with some kind of insurance. And they say that 1 year is not a reasonable period, and when there are only proceedings for the insurance or asking for the real estate, and in that case some public notaries contributed that all of them who needed these services could come to them very quickly, very efficiently. There were some difficulties that there was not enough number of public notaries, but with the change, with the amendments of the law, there is additional criteria with the new number, the new public notaries. And they were distributed for some of the courts. So it may mean just the certification of the signature. The country said that there is a decrease in the tariff. I can say that previously that the certification was 16 euros in front of the public notary, but when it was on the general proceeding, it is €1.60, €1.60. So the country, the state contributed greatly that they can get to the things that they need in their everyday life. Somehow we agree all, and we in Slovenia think that, and the colleagues in Croatia, when they established the public notary systems, we lost some of our business. The people who said, those who would say that they did not lose anything, they would probably lie. If we lost some of the things, and there are some other things that come out, we gain something. There are some things. There are some things that the public notaries are authorized. They do them. They do not them. They send these issues to the lawyers or attorneys at law, and our clients can more efficiently come to the solution now than the situation was previously. We agree that some of the issues, some of the things were cheaper. in previous times, but now when we do it at the public notary, it puts the amount of the tariff, and there in later years there was the court tax. And according to the statistical data, we haven't noticed that the clients who did that at court or city hall did that less than in these public notary systems, since they had to wait for a long time. All these requirements were in Greece. It depended on the economical situation, not about the number of people. It is reflected about the less percentage, less loans and some other similar things. So we consider this public notary system not as an opponent, but something that contributed to our clients to obtain the services more efficiently. Some services that they were waiting for a long time. That there is a proposal in the year 2012 by our government that some issues should be transferred to the public notary system. Some of the things that are related to inheritance and non-litigant proceedings, and there were a lot of amendments to this proposal of the law. There were a lot of lists, waiting lists for that. All these court proceedings went to the reasonable time, and the transfer from the court to the notary is rational. So that was the proposal that was transferred. So the court that was for that proceeding. I would conclude now. I hope that it did not take me long. I would just wanted to shortly present you, and I think that if you come to this amendment to your law, that would enable the regular work of the law on public notary system, that you should not consider that as the enemy, or that would contribute to our clients. If the clients or those who are satisfied with the legal services, those are the legal services of the barristers or attorneys at law. And that is something that is most valuable. Thank you. I would kindly ask Mr. Branko Maric, the representative of the Bar Association of Bosnia and Herzegovina. Dear colleagues, I would just to consider the first task, and that is the relationship of the legal profession and the Ministry of Justice. It cannot be worse. It has all the attributes that you would say to your minister that I dare not say as a guest here. He is the man who is cannot completely manage the contact, since those are not professional persons, and they are afraid to get into the dialogue. So they are hiding because by the way that they raise the fence towards us. This is not professional, and the lack of capacity to deal with the issues. They have the great influence on the relationship of the ministry and the foreign counselors. and we have the same donator for the public notary system. These are Germans, and or their profitable organization, and it cannot channel this help. It cannot use the help without allowing to establish the institutions that are not acceptable, that cannot be implemented in our legal system. I can say that traditionally in Germany, public notaries draft the statutes of the societies. According to these statutes, they establish their societies. So in some countries, for example in Bosnia, the statute is not the establishing act of the society. The contract is in fact the establishing act. So we have the German model of notary system. So that means that the establishing act should be drafted at public notary's office. There is a collision of interests. The law says that it should be drafted on the part of a notary. It is the wrong interpretation of what it means to the establishing act. It cannot be put into one contract since there is the conflict of interest, since the public notary does for both of these sides. And this is what is dangerous. This is what is dangerous both in Bosnia and Serbia. I would like to pay your attention to, if you go into the direction, since you have all the donators that we have in Bosnia. This is the law on establishing the legal help that was established in Bosnia, which is not acceptable because there are not financial means, and all the counties have their own agencies for providing legal services, and they are practically working illegally because the county, they have the expenses for their salaries, and for providing the services they do not have enough support. They established that in the system, and no one has asked whether it could be good services in our circumstances. For example, in Greece, there is a special way of taxes, and so they can be financed in that way. And everything is done by the head of the Americans. So it cannot function that way. And when it comes to the notary public, I would put it this way: we would like to have the system that there is in Croatia and Slovenia. Then public notaries would be our dear friends, and unfortunately we have the same system that we have in Serbia, that there is exclusivity of public notaries when it comes to different areas. It was established in our country 7 years ago, and it has not been sold so far. Public notaries had the space to develop their activities on our territory. I would not go into details because these laws are practically identical. After 7 years, the first consequence, let me put it this way, that the people who gain the profit came from, were not anymore the lawyers, but the notaries. So they became the ones who are taking the money from the clients, from the people. So now the system is not the hen that lays golden eggs nowadays, not even for the public notaries. There are the tariffs that are good for those people who are close to the authorities. So what the notaries are doing are just less tariffs than the tariffs that would be covered by the attorneys at law. It cannot exceed the amount of 600 euros, so it is not favorable business. If we neglect the family regulations, they can do some things that are related to real estate or contracts or statutes of the organizations or enterprises. When it comes to the statutes of enterprises, a serious investor would not go at a public notary. They would go to the lawyer, and that means that they did not any harm to the lawyers, because they pay the same expense, and additionally they would pay the public notary as a technical service. And on the other side, when it comes to the contracts of any type with the exclusive authority of the real estate, then there is great damage. So it comes from the legal profession that there is a problem if we change the law, how to gain the clients again. The clients got used to go to the public notaries for these years. So there will be the problem how to describe to them, how to explain that the lawyers also do that with the last tariffs. This is presented the dark scenario that can happen if you do not succeed in your endeavors. The same wishes as from my colleagues from the Bar Chamber that you should succeed in this. Thank you very much for your attention. The continuation of the insight, our colleague Nikica Kršević from Sarajevo will give the insight. Good afternoon, dear colleagues. I would like to briefly say and give the insight of the relationship. He did not mention the relationship of the public notaries, state authorities and the legal profession. I'm the member of the managing board, and when it comes to after the protest of the lawyers in Serbia, we got criticized from our colleagues why we didn't do that in our case, so that we should have done that. When we think about that, maybe we have done well, we were wrong. Having the reaction of the membership, having in mind the solidarity, we think that we skipped this step, and we came to the situation that colleague Branko described. If we ask what we want, we can get it on a declarative level. In fact, we cannot gain anything. There is the proposal for the evaluation of since there are certified representatives, 4.5 years ago, this system, this issue has not been solved. This is the longest solving problem. It shows the relationship of the government according to the legal profession and what the President said, the Ministry of the Executive Authority, the Judicial Authorities, and the Constitutional Federation. From the media and the contacts with my colleagues, I know that there is this some kind you will not get from your request, regardless to all the wishes of mine and yours. First of all, I would like to send greetings and the support of all the members of our Federation of Bosnia and Herzegovina for your efforts. Not what the state said that they offered to support your clients in Serbia. Not in that case. That is not true. The Bar Association of Bosnia and Herzegovina has found that, and it is our statement that no one is willing to come to Serbia. That is the violation of the duty, and at the same moment the person who does that would be suspended. If you find out about that, please inform your authorities so that we can take the appropriate measures. So completely identical law and the limitations. This is what we have for this period of 6 and 7 years, and the problems that are stated by colleague Maric are still present. This is not the problem of the lawyers or public notaries, it is a problem of our citizens. There are the simple proceedings of inheritance that deal by they said that there will not be expenses. If the pension is 100 euros, we will take only 20. We know that we cannot, how we deal with the inheritance or the things that were left after the deceased person. There is no court tax that is charged for that, but of course there is a tax for notary services. So 20 euros is 20%. Plus, when it comes to the real estate or other properties, then there is the increase in the tariffs that are paid to the notaries. There are the services to physical and personal and other persons that are offered by the public notaries. They should provide their services according to the high standards, and their service should be equally at equal disposal to all the citizens, and those legal and physical persons should have the freedom of choice. The same as the freedom of movement, or since the national boundaries are not the limits, the principle is what is put in the directive in the year 1998. So these two countries, Bosnia and Herzegovina and Serbia, are not the members, but they have to apply these directives that are recommendations, that are not obligatory. They have to be implemented in the legal system, both in Bosnia and Herzegovina and Serbia. Both notaries and lawyers have to fulfill all the conditions when it comes to legal competencies, So we should have approximately equal conditions when it comes to documents and guaranteed rights. And the citizens should also have the freedom of choice in order to protect their legal rights. With these controversial laws in the Federation of Bosnia and Herzegovina, as well in Serbia, there is a series of solutions that are not in congruence with the Constitution, with the international documents of the human rights and the international law that our Constitution referred to these laws. We support all your requirements. Thank you. Thank you, dear colleague Kecilic. I would like to ask the colleague from the Bar Association of Hungary.
Inviting the Hungarian Bar Association to this very important meeting. I'm representing for inviting the Hungarian Bar Association to this very important meeting. I'm representing here our President János Bánati, who is sending his best regards, and on his behalf also I would like to express our full solidarity with your stoppage of work here, because we also consider that the measurements the government took against the legal profession here in Serbia is not according to the European standards. I'm standing here in front of you also in another capacity of mine, being the chair of the CCB working group regarding to all kinds of notarial matters. So together with Ranko, who is co-chairing the PICO committee of CCB, we will be organizing the Saturday meeting in Brussels, where we hope that we will have the possibility to discuss a more practical aspect of the situation you are suffering here. However, my task is today here as a Hungarian lawyer to tell you something about the Hungarian situation in between the notaries and the lawyers. Hungary is thank you very much. In Hungary, the situation is also quite peaceful between the two professions, like we heard in Slovenia or also in Croatia. There is a significant difference between lawyers and notaries regarding their status, tasks and social functions. At the same time, we think it is crucial for the efficient cooperation in the interest of the clients, the society and economy. So we are working in a fairly good relation with the notaries. The notarial system is not new in Hungary. It was always existing since the 19th century. Of course, they have their historic roots centuries back, but in a formal way, both professions were established during the 19th century, as most of our nations lived in the frame of the Austrian-Hungarian Empire or around the empire, and the legislation system were more or less the same. So I think the roots are definitely the same. On the other hand, we see in the whole Europe that there are very different systems, where there are systems where the notaries are really very strong. They have such an economic power by which they are controlling certain fields of law, like in Germany or in Austria, corporate law, real estate law. In Hungary, the situation is different. There is no document of any kind which is to be drafted in a form of a notarial deed, in a public deed as such. Of course, there are exceptions if someone is blind or illiterate or whatever special circumstances appearing, but as such, no obligation is existing in Hungary for any sort of documents to be drafted in a notarial deed. Of course, there is an option for the public, for the clients, to choose in between the various forms. There are certain documents which require a higher legal level certainty, which are to be drafted either by a lawyer or by a notary, but this is completely the choice of the client, or obviously it's depending on the purpose for what the document is going to be used. So therefore, the cooperation is obvious and necessary. I think the details at this point and this time are not important. So therefore, I took the liberty to see what are the main characteristics of the two professions in Hungary now, where we can compare the two professions with each other. And the most important difference is that, and I would say half of the principles are coming from this basic principle that the lawyer gives advice and the notary does not give an advice. The notary is an independent person, while the lawyer is a person who is loyal to its client, acts in the interest of the client, while the notary acts in the interest of the legal perfection. So that is the main difference. Throughout the last 25 years, there were lots of issues, and the result of those, the legislation on notaries as well as on lawyers got to the constitutional courts, and the constitutional courts passed several decisions, and these decisions became the basis of the future legislation where we are now, as we are regulated now. Both of the profession is declared to be part of the judicial system. Lawyers is a definitely private activity within the judicature, and the notary is a state representative of the judicature, of the judicial system. As I mentioned, most of the characteristics are coming from the different positions. The lawyer works on a mandate agreement, so he is in a contract with his client. The notary is not in a contractual situation. The nature of the service he is providing is more a public law-like service. Has a public law character because he is providing the services upon the application of the client. So the client asks for the services. There is another characteristic which is also very important, that the lawyer can refuse the client. I don't take your case because this is a dirty matter, whatever. I don't want to, I have not the knowledge or whatever, but I can refuse as a lawyer. The notary is not in this position. There is an obligation for the notary that if the client fulfills the legal conditions, presents the necessary documents or authorizations, then the notary has to act. He is not in the position to refuse the task. The next issue and the next difference is also coming from this aspect. The legal fee between a client and a lawyer is subject to a completely free agreement. There is no limitation of any kind in Hungary, and it is clear that if a limitation can take place somewhere in the future, so the lege ferenda, perhaps, if we are talking about this, this can be based only on state origin legal acts, but not on bar decisions or any other kinds of lower decisions. On the other hand, the the notaries are acting according to a fixed fee scale published by the Minister of Justice. Same as I think both of you mentioned regarding Slovenia and Croatia, the notaries are competing with each other, which results in a decrease of the fee according to this fee scale published by the Minister of Justice. So there are, of course, various issues when the notary can increase the fee. For example, if he receives the draft from a lawyer, then it is a reason to decrease. If he has to do that by himself, then he can increase. If it is a foreign language document, once again, or if it is done at the client's office and not in his office, this is also a basis for the increase. But the notaries very rarely validate this possibility because they are competing with each other. I think that the general approach is that the number of lawyers and notaries should be in a very close relation with the tasks. Just to give you figures, we have in Hungary 10 million inhabitants, 12,000 lawyers, and 314 notaries. Notary offices, I would say, because in most offices there are notary substitutes acting as well. So altogether, we are talking about roughly 700 professionals in a notarial capacity. So it means that you can see very clearly the difference between the numbers. And of course, the notaries never ever thought about drafting agreements of their own. They are working together with the lawyers because we are acting with the clients. Of course, they are also acting with the clients directly, but about totally different topics. We are talking about the business structure. They are talking about the, so to say, legal perfection. So how that the most important character out of these legal characteristics that the document should be enforceable, because that's their level of liability. That's the key horizon of their liability. If they are drafting a deed which is not enforceable, then it doesn't make any sense to make use of services of a notary. There are a few other characters also which I would like to mention. Of course, the notaries are appointed by the Minister of Justice. They have a territorial competence, which is not the case for the lawyers. Everybody who achieves certain conditions can apply for a membership in a bar association, and if there is no negative condition met, then he has to be accepted by the bar and become a lawyer, and he can act in all fields of law and in the field of the whole country. So we can summarize that the legal activity conducted by the lawyer is a less formal, and the legal activity conducted by the notary is a more formal activity. The notaries getting also in Hungary more and more procedure in the last 2-3 years. These are the so-called non-litigious procedures, registry, conducting certain registries. They have a very strong bar association. They are financially very strong because they gained a lot of money from the wave of the credit boom in the early 2000 years, and they collected a lot of money out of these, and they set up an extraordinary IT system, which now functions much better than the electronic system of the court. And having this system already introduced, certain tasks from the court goes to the notaries. They have a very sophisticated system how they share the income in between the bar and the individual notaries, which makes both the profession and the bar very strong. Honestly, I have to tell you, much stronger financially than the bar associations. Finally, I think I would like to demonstrate the situation in Hungary with a European example. Probably you have heard about it. There was an infringement procedure against 6 or 7 EU countries most recently at the first instance court of the European Union in Luxembourg. The subject matter of this procedure was that those countries, Spain, France, none of our countries were included, are setting the citizenship as a condition precedent to become a notary public. And the decision of the European Court decided that this is against the European norms, so these countries are now obliged to dismiss from their legislation the precondition of the local citizenship for notaries. The Hungarian government still maintains that the Hungarian notaries are so much different from those countries, from the notaries of those countries, like, for example, France, Austria, and some other Western European countries, that the Hungarian government have enough argument to claim that the Hungarian notaries are so strong allied with the state that, and this is accepted everywhere in the European legislation, that the decision-making process can be kept in the hands of the citizens, that the Hungarian government are willing to claim at the European Union that this law should not be applicable to the Hungarian notaries. And this is, I think, something which shows you very clearly that the Hungarian notaries are so closely tied with the state that, and of course our profession is so private one that there is no real conflict in between the two professions. But to come back to the and finish with the original issue, I think we have to see always problems like this, what occurred here in Serbia, as an issue of and the problem of access to justice, the problem of the citizens, and I think this is the strongest argument in our hands, that we are fighting not primarily in favor of our interest, for the interest of the lawyers, but we are fighting for the interest of the clients. Because if the clients cannot get to the justice, then the whole system is dead and cannot work. So I am very pleased that we received this invitation from the Serbian and the Vojvodina Bar, and we are wishing you a lot of success in your fights. And what I can promise you myself also, that we will do the best for you together also in Brussels in the frame of CCB. Thank you very much.
Dear colleagues, first of all, I apologize for my voice. I literally lost my voice when I heard that public notaries did not exist in Serbia. This is true, it never happened to me. We thank you very much for your invitation, and we represent the national permanent commission of the union from Romania.
În calitate de membru al Comisiei Permanente a Uniunii Naționale a Barourilor din România, forul executiv al acestei profesii, reprezint la această întâlnire pe domnul președinte, avocat dr. Gheorghe Florea.
We are representing the president of the National Union of Bar Associations from Romania, Mr. Gheorghe Florea.
Vă mulțumesc că mi-ați dat posibilitatea de a reveni la Novi Sad, unde de fiecare dată, în calitate de avocat și de vecin, avocat în Timișoara, m-am simțit foarte bine.
We thank you very much for giving us the occasion to come back to Novi Sad, where we have always had a very good time, as we are neighbors and very good friends.
Aș dori să vă prezint câteva aspecte legate de organizarea notarilor din România și colaborarea corpului profesional al avocaților cu Camera Notarilor.
We want to expose a few aspects of the public notary profession and of the lawyers profession in Romania.
Ca să precizez de la început, din 1954, avocații români nu au mai putut încheia acte care să consfințească transferul dreptului de proprietate.
Starting from 1954, Romanian lawyers were no longer able to conclude contracts or documents in which the transfer of property was operated, this being the exclusive possibility of the public notary. So in other words, in Romania, public notaries have been around for a long time.
Ca urmare a măsurilor adoptate legislative, în 1954, avocații, notari și consilierii juridici au format o direcție în subordinea Ministerului Justiției, funcționând în acest fel până în anul 1990.
Starting from 1954, the lawyers, the public notary and the legal assistants were under the direct coordination of the ministry, and they functioned like this until 1990.
După 1990, avocații s-au desprins de Ministerul Justiției, au creat Uniunea Națională a Avocaților, urmați la scurt timp de consilierii juridici, doar notarii au rămas în componența inițială sub tutela Ministerului Justiției.
After 1990, only the notary publics remained under the direct authority of the Ministry of Justice, and the lawyers practically liberalized their profession.
Privind retrospectiv și analizând situația existentă astăzi, considerăm că au făcut cea mai bună alegere.
Looking back in history, we consider that they took the best option.
Dumnealor și-au redactat o lege care le-a dat posibilitatea să se privatizeze sub patronajul Ministerului Justiției în anul 1995 și să aibă organizații profesionale proprii.
In 1995, the public notaries liberalized their profession, but remained under the direct authority of the Ministry of Justice.
Trebuie să constat cu regret că începând cu privatizarea notarilor au apărut și probleme de colaborare între avocați și notari.
After the public notaries liberalized their profession, the problems occurred between the lawyers and the public notaries.
Am să scot în evidență câteva aspecte care mie mi se par semnificative.
We will tell you about several aspects that are very significant for this competition between the two professions.
Numărul redus al notarilor comparativ cu al avocaților în zona de activitate a acestora. Spre exemplu, sunt organizați pe curs de apel.
First of all, there is a very small number of public notaries in comparison to lawyers. They organize their profession next to courts of appeal.
În Timișoara, Bunăoară, sunt 800 de avocați și sunt 50 de notari.
In Timișoara, there are over 800 lawyers, but only 50 public notaries.
A doua nemulțumire sau neplăcere creată corpului profesional o reprezintă modul de selecție al notarilor.
Our second regret is the way that they select the new notaries that come into their profession.
Noi am apreciat întotdeauna că există un mod preferențial și că se intre foarte greu în corpul profesional al notarilor.
It is very difficult in Romania to become a public notary, whilst it's fairly easy to become a lawyer.
Sunt foarte puțini avocați care de la înființarea Camerei Notarilor au reușit să intre în Camera Notarilor.
There are very few lawyers that have succeeded to transfer their profession to become public notaries.
Este greu de înțeles cum avocați cu 15 sau 20 de ani de vechime în profesie nu pot accede în Camera Notarilor.
It's very difficult for us to understand how lawyers with 15 years of experience cannot take the exam to become public notaries.
A doua chestiune care a trezit numeroase discuții a fost modul de stabilire a onorariilor.
The second issue regards the expenses that are established by the public notaries.
Este adevărat că la avocați nu există tarife minimale și maximale, pe când la notare există, numai că aceste tarife sunt stabilite și controlate de către Ministerul Justiției.
It is true that lawyers do not have minimal fees, whilst the public notaries do have them, but the minimal taxes of the public notaries are controlled by the state.
Deci nu există o piață concurențială în rândul notarilor, pentru că dacă mergi la 10 cabinete notariale, onorarul care ți-l stabilesc este apropiat de aceluilalt confrate.
There is no free market between the public notaries. If you appeal to 10 different public notaries, the taxes will be practically the same.
Este adevărat că la avocați nu există tarife minimale și maximale, dar degeaba ceri un onorar mare dacă clientul nu-l poate plăti.
It's true that the lawyers do not have minimal taxes, but it's no use to establish a very high fee if people do not have enough money to pay the lawyers' fees.
Notarul, indiferent cât cere onorarul de mare, clientul trebuie să-l plătească pentru că nu poate să facă actul în altă parte decât la cabinetul notarial.
So people are basically obliged to appeal to the public notary even if the tax is very high.
Sunt discuții foarte serioase și în ultima perioadă o mare nemulțumire a trezit în rândul avocaților. Au trezit unele reglementări legale care dau în exclusivitate unele acte întocmite doar în sarcina notarului.
New regulations have established for the public notaries certain non-litigious procedures.
Clientul nu are altă posibilitate decât să accepte condițiile notarului.
The clients have no other possibilities but to comply with the conditions of the public notary.
Iar cea mai gravă problemă a fost că s-au dat unele activități avocațiale și în sarcina notarilor și aici mă refer la acordul pentru desfacerea căsătoriei pe care notarul poate să le ia părților prezente, eludând astfel serviciile avocațiale sau ale instanței.
The biggest problem is that certain procedures that belonged before to the lawyers were attributed directly to the public notaries, and we give as an example the divorce. Now in Romania, if the parties agree to the divorce, they no longer have to go to court, they go directly to the public notary and the public notary states their divorce.
Toate aceste situații anormale, considerăm noi, au trezit multe nemulțumiri avocaților.
Lawyers in Romania are not at all satisfied with these new regulations by the state.
Și atunci am să încerc să vă dau un răspuns pentru că am fost întrebat și de către unii din dumneavoastră ce au făcut avocații români.
Now we will try to answer the questions that have been put by some of colleagues. What did the Romanian lawyers do when this happened in Romania?
Deci noi am încercat să oprim emiterea unor legi care conțin astfel de prevederi ce au trezit ce-au trezit nemulțumiri în rândul avocaților prin opoziție la elaborarea legilor.
Indeed, we tried to combat the legislative power not to establish such laws in the exclusive favor of the public notary.
Din păcate, toate observațiile făcute de Corpul Avocaților au fost în mare parte respinse, rămânând doar calea atacului la Curtea Constituțională pentru constatarea sau prin invocarea excepțiilor de neconstituționalitate ale legii.
Unfortunately, all our efforts have not succeeded. We can only go to the Constitutional Court to regain the rights that we had exclusively before. Because, in our opinion, the public notaries in Romania have a much better sustainability in the Romanian Parliament.
Am considerat că o măsură de forță ar avea șanse zero de reușite și am considerat că este necesar să purtăm un dialog cu confrații noștri notari.
We considered that a protest similar to this one going on right now in Serbia would have zero chances for success, so we preferred to have an open dialogue with our fellow notary public colleagues.
Nu știu dacă a fost calea cea mai bună sau cea mai dreaptă, dar am considerat că este singura.
We don't know if it was the best way, but it was the only way to have an open dialogue with the notary publics.
Personal vă doresc din suflet să aveți succes în demersul pe care îl veți întreprinde și vă asigur de solidaritatea avocaților români.
We wish you the best of luck in your effort for success, and we fully support your efforts from Romania. Thank you very much.
Zahvaljujem se predstavnicima advokatskih.
My thanks to the representatives of the Bar Association of Romania, and I would like the representatives of the Bar Association of Macedonia to come. My greetings to all of you present here. Thank you for your invitation for the Bar Association of Macedonia to take part here and give its contribution to for finding the solution of the problems. Our colleagues have said a lot, mostly the negative things when it comes to the relationship of the notaries and the legal profession. So it deals with the legislative system that deals with this relationship. First of all, we have this legislature in 1996 with a couple of amendments did not disturb good relationship of the legal profession and the public notaries. It was the correct relationships. The problems aroused in the year 2007 when the Assembly of the Republic of Macedonia passes the completely new law on public notary system with the new Latin public notary system, which means the disturbance of all with the things that we have in our system in pursuing our profession. There were 4 amendments, and each one of them represented the demolishing of the legal profession and increase of the business and the authorization of the public notaries. I can rather tell you what are not, what are things that are not in their authorities. So I would not like to repeat the things that my colleagues have already mentioned, especially the colleague from Novi Sad. Public notaries in Macedonia can certify the signatures. They can
confirm the private statements. They can solemnize the documents. The contracts for real estate contracts between spouses and concubinage partners, and all these acts regulated by the different statuses. That means many things that I would not like to enumerate here. There is the Article 45 that says that public notary, the solemnization and authorization of the private document checks everything that is done upon the draft of the statement, and it has to be done upon the proceedings that was done in the proceedings, and which automatically excludes the lawyer in this sphere. These problems have been present from the year 2007. Some of you were present at the election of the Bar Association, and we supplied the suggestion for the amendments of the law. At the beginning of September, there is the Economic Council of the government, and the government accepted that and announced that to the Ministry of Justice. This is what is supposed to be in this law. The necessary presence of the lawyer while drafting the document that include the values higher than 20,000 euros. There is the exclusion of the legal representative or lawyer when one of the contracting party is the bank or some or other enterprise. The solemnization in the value of the amount that exceeds 10,000 euros. For the contracts, the presence of the lawyers and lawyer stamps which exceed the value of 10,000 euros. The decision of money order, notary money order, and for the issue upon which it is issued. The real estate contracts non-presence of the lawyer and not providing the stamp of the lawyer, it is the public notary can reject that case. So the Resource Ministry of Justice has already done that, and we're expecting that this amendment should be at the Assembly of the Republic of Macedonia. If we succeed in passing the law, we have done a great step in establishing a step in the relationship between the legal profession and the public notaries in the Republic of Macedonia. Ladies and gentlemen, dear friends, for the end of this round table, I would like to read the text of the resolution that we drafted. Representatives
of the bar associations and participants to the roundtable current issues of the legal profession and relation between the legal profession and notaries held in Sremski Karlovci on November the 25th, 2014, considering the rule of law as a basic principle and precondition of the Constitution of the Republic of Serbia, considering that every state being established upon the principles of the rule of law, democracy, human rights and freedoms, must build into its legal system all principles provided by the Charter of the United Nations, Universal Declarations of the Human Rights, International Covenant on Civil and Political Rights, European Convention for the Protection of Human Rights and Fundamental Freedoms, and other international instruments that means principles on promotion and respect of human rights and basic freedoms, equally before the law, legal aid and representation by the attorney, right to free expression of will. Whereas the legal profession is the free profession and the occupation within the public order system, the attorney is considered a special factor of the judicial system. The attorney has a professional duty, beside protection of violated individual rights of a client, to contribute in his or her public activities to the rule of law, legality and justice, considering that at this very moment the freedom and independence of the legal profession have been legally imperiled in the Republic of Serbia. On the protection of freedom and independence of the legal profession as one of the fundamental conditions for the rule of law accomplishment, they shall ensure the efficient procedures and adequate mechanisms for efficient and equal access to legal profession are provided to all persons without any discrimination based on race, color, ethnic origin, gender, language, political and other opinion, national or social origin, property, birth, economic or any other status. States shall ensure equality, free access to justice and legal certainty to all its citizens. Every citizen has the right to an attorney upon his or her own choice, respect of his or her will and professional secrecy by the chosen attorney. All aim to protection of his or her rights and interests exclusively. Any infringement of the exclusive authorities into independence of self-regulation of the legal profession is considered inadmissible. Legal profession is regulated by its own internal regulations with respect of all internal and international rules. Legal profession is obliged with regard to the nature of the profession to indicate limitations of the legal system, violating the rule of law and legal certainty. Representatives of the bar associations hereby consequently declare to full and unreserved support the justified protests aimed to the protection of freedom and independence of the legal profession and fundamental human rights and freedom in Sremski Karlovci on November the 25th, 2014. The resolution is prepared for your signatures after the short break.
Ranko dolazi samo nešto.